Hi everyone, welcome back to Law with Dunk, the Law Guy, and we're on day 7 of the Case a Day series, where at least from Monday to Friday I will go over legal cases relevant to criminal law, tort law, contract law, and the English legal system. Seeing as omissions have been covered, I thought I would explore other ways the actus reus of a crime can be committed before I eventually move on to causation cases, mens rea cases, strict liability cases, and then non-fatal offences against the person, and all the other topics for criminal law. And that's just one mountain to climb. We've then got all of tort law, contract law, and the English legal system too. So back to the foot of the first mountain known as criminal law. As stated in the video for day 2, where I covered R.V. Gibbons and Proctor, I stated how the physical part of a crime, or actus reus, means the guilty act, and is usually committed via a positive voluntary act, or a willful act. I then went on to state how the actus reus can be committed by way of a state of affairs crime, or an involuntary act, and even by way of an omission, provided there is a duty to act. For a positive voluntary act type of an actus reus, I'd like to do a 2-for-1 special today. So starting with the case of Hill v. Baxter, 1958. This case helps illustrate that where the defendant does not have any control over their actions, then they will not have committed the actus reus for a criminal offence. Specifically, there won't be a positive voluntary act, which is the most common form of actus reus. In this case, the court provided examples of where the driver of a car would not be acting voluntarily, such as losing control of the car due to being stung by a swarm of bees, or if he was hit on the head by a stone, or had a heart attack whilst driving. Another case example where there won't be held to be a positive voluntary act can be seen in the case of R.V. Mitchell. In this case, the defendant was pushing his way into a post office queue and he was challenged by a 72-year-old man. The defendant punched the 72-year-old man, which caused the man to fall backwards into an 89-year-old lady. The lady fell over and was injured and died a few days later from her injuries. The defendant was found guilty of unlawful act manslaughter. Here, his battery caused her death. The 72-year-old man who'd been punched and fell against the old lady wasn't criminally liable because he wasn't acting voluntarily when he fell against the old lady. Seeing as there was no positive voluntary act from the 72-year-old man, this meant that there was no actus reus committed by him, hence why the 72-year-old man wasn't guilty of any criminal offence. And that's it for today. Thank you from Law with Dunk, the Law Guy. I'm definitely not the man of tomorrow, but I will see you tomorrow.